Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're going to talk about a dispute relating to a Quistclose trust, or an alleged Quistclose trust, and a subsequent loan agreement. And working through that, we're going to come to get a bit of an understanding of how these sorts of relationships can unfold when they're litigated before a court. What are we talking about today? We're talking about a plaintiff, and a plaintiff is someone who kicks off legal proceedings, and that plaintiff sues a number of defendants. Some of those defendants are companies, and some of those defendants are natural persons, flesh and blood persons. Now, in relation to the flesh and blood persons, one of those flesh and blood persons is not served, not formally given the relevant court documents, and so the plaintiff's not in a position to proceed against that natural person. Another of the natural persons, one of these flesh and blood persons, is bankrupt, so the plaintiff is not in a position to pursue that natural person. And so the actual legal entities that the plaintiff is pursuing today, they are all companies, right? They're all Pty limited. They're legal people, but they're not natural people. No sort of blood and bones and desire for coffee or any of these sorts of things. So the nature of the relationship, the basis for these proceedings today, relates to what we might loosely call a property deal that sort of began in 2017, then followed another agreement made in 2018, and then a failure to sort of pay back this invested sum. What we've got is the plaintiff's parent meeting with a number of the defendants, the natural person defendants, to discuss a property investment opportunity. Now, following the plaintiff's parent meeting with some of the defendants to discuss this property investment opportunity, what we have is the plaintiff themselves then paying the amount of $9.2 million into the hands of one of the defendants. That $9.2 million is then distributed out to some of the defendants, and some of it's paid off to sort of third-party parties like accountants who help with deals and lawyers and that sort of thing. But essentially, we have the plaintiff's parent meeting, and then subsequent to that, we have the plaintiff paying this sum. What we also have is sort of a suite of documents that are circulated at around this time that refer to some sort of real estate properties, and there's the flavour that this sort of arrangement is going to be for the investment in some real properties with the hope that there's going to be a return. Now, the nature of this sort of loose, unwritten arrangement that's reached is that hopefully in a year's time, we're going to get a 35% return on this 9.2 million. Or if we haven't sold a property, then we're just going to pay the principal sum back. And that's sort of the agreement that is sort of accepted, that is on foot by all the parties. Now, what happens in 12 months' time is, sadly, we haven't got that 35% return happening, nor have we got the principal returned back to the plaintiff. And so what the plaintiff does is then cause everyone to enter into another loan agreement. When I say another loan agreement, there wasn't a loan agreement up front. There was that unwritten arrangement, if I'm speaking loosely about it. And so we've got now a written loan agreement being entered into, and that loan agreement has terms like repayment, terms like interest, and what we might think of, if we're speaking about it loosely, as being a slightly sharper, more precise, more readily understandable, with great respect, sort of arrangement between the parties. Now, despite the 2017 sort of arrangement and the 2018 loan agreement, these amounts are not repaid by the defendants, and so the plaintiff finds himself in a position where they're having to commence these proceedings. And so, the way the plaintiff frames the position is to say that the funds are held in trust for the benefit of the plaintiff, and that trust is a Quistclose trust. That trust is essentially a purposive trust, if we're speaking about it loosely, which is to say, I paid you these funds for a specific purpose. If that purpose was not achieved, then those funds are held by you in trust for my benefit, and you've got to pay them back to me because they were only paid to you for this purpose. Purpose wasn't achieved, so pay them back. Now, that's a fairly specific claim with, as you might imagine, fairly specific legal ramifications that the plaintiff has to go ahead and engage in. Now, the nature of the claim, if you're going to claim that someone holds something for your benefit pursuant to a Quistclose trust, is that there is a mutual intention between both parties that there's this specific purpose achievement and then if the specific purpose is not achieved, then the sums are held on trust. And so the mountain that the plaintiff has to climb in bringing their claim is to show to the court that there is this mutual intention, that there is a specific purpose that the money has changed hands for, and that if that specific purpose was not attained, then, gosh, this coffee is delicious, I'm sorry, then the amount has to be repaid back to the plaintiff. And so we then have to get into the nitty-gritty of how the payment was made and what was going on. Remember, it was the plaintiff's parent who met with some of the representatives of the defendants, and it wasn't the plaintiff themselves. And so the plaintiff wasn't really able to point to any specific conversation. There was no evidence of that sort of thing before the court. What the plaintiff said was, there were some documents that were circulated at around the time, and those documents sort of referred to a few properties and seemed to focus on one specific property. And so it was those documents that referred to this property that constitute the mutual intention between us, that the reason I paid you this money was for the specific purpose of using the money to invest in this specific property, and then to bring the argument that says, look, we didn't end up buying the specific property, so you hold that money on trust to be repaid back to me, which is the plaintiff's claim. Now, the big challenge that the plaintiff faces is the court finds that's not actually what the evidence shows. The evidence doesn't show there was one specific property or even a number of specific properties. The evidence doesn't show, sadly for the plaintiff, that there was even an agreed size of, X hundred acres or whatever it might be, X hundred hectares or whatever it might be. The plaintiff's unable to point to a really specific representation in order to ground a really specific mutual intention to create this trust. And so what the court does in reflecting on this evidence is sit down and say, right, has the plaintiff done what he needs to do, what they need to do, I should say, they are a natural person, what they need to do in order to prove that there is a Quistclose trust? The court finds no, for a number of reasons. One is the plaintiff pointing to the creation of a JV vehicle, of a SPV, a special purpose vehicle, being incorporated to sort of go ahead and pursue this property investment opportunity, is not itself enough evidence of a mutual intention to create a trust. Secondly, there's an absence of what we might loosely as lawyers think about a trust account, or like some way of stopping monies held in trust from being mingled in with monies held for another purpose. So there's no evidence of a prevention of this sort of intermingling of money's risk, and that sort of tells against there being a trust. In all the evidence, there's no suggestion, there's no words like solely or exclusively, no words that kind of really point to this kind of specific property, specific mutual intention to create a trust sort of argument that the plaintiff's looking to raise. And then generally, the way that the parties behave is that they're treating this money really like a loan versus a sum held in trust for the benefit of the plaintiff. And so the court, in considering those criteria, says, look, we've taken a look at it, and the view we've come to is the correct reading is the money's not held in trust, and so the plaintiff fails. The next step is, do you remember that the defendant said, look, even if the money's held in trust, the loan agreement comes in and supersedes it? Or if you don't remember that, and if I didn't tell you that, that's what they said. And so the court says, okay, well, let's move to the next step in the consideration. Let's assume that there is a trust. Let's now address the question of whether the loan agreement had the impact of extinguishing the trust. Because do you remember it was 2017 that this alleged trust relationship was set up, and then it was 2018 that there's this subsequent more formal written agreement. And so the short point is the court finds, yes, that the 2018 loan agreement had the impact of extinguishing any trust rights that might have flowed from the 2017 arrangement. And there are a number of reasons for that. One of them is that the rights created in the loan agreement sort of superseded and were inconsistent with the rights created pursuant to the trust, and there are additional rights granted to the plaintiff, rights like repayment, rights like interest, that are sort of inconsistent with this trust arrangement. And also, frankly, the loan agreement was entered into after the trust arrangement with the apparent intention of sort of extinguishing the impact of any former dealings. And so the court finds if there was an intention, a mutual intention to create a trust relationship, then nonetheless the loan agreement extinguished whatever rights the plaintiff might have pursuant to that trust relationship. The next question for the court to consider was, okay, if we are wrong and there was a mutual intention to create a Quistclose trust, and if we are wrong and the loan agreement did not extinguish any rights the plaintiff might have pursuant to the trust, then is there a right for the plaintiff to go and pursue these companies? Because do you remember that the plaintiff sued these natural people, these natural persons, but wasn't able to actually pursue them, and the substance of this litigation is against the companies. And so the basis upon which the plaintiff is pursuing these companies is for things like knowing assistance and knowing receipt of trust funds. And the really short point is that the plaintiff fails to make out that even if there was a trust, and even if the trust was not extinguished by the loan agreement, which the court finds against the plaintiff for on both counts, then nonetheless the plaintiff would be prevented from pursuing the companies on that kind of knowing assistance, knowing receipt, voluntary receipt kind of, various sort of tracing style remedies if we think of them that way. And so the plaintiff loses on all three heads of their potential claim, and as we lawyers sometimes say, costs follow the event, which means having lost the litigation, the plaintiff has to face the defendants who won the litigation, speaking loosely, enjoying the benefit of a costs order against them. I hope that discussion assisted you, and I look forward to joining you again soon for another coffee and another case note. Cheers.